Saidu, Professor Manohar, Professor Sitaram Rao. Actually, it's frightening to be amidst so many dons on the dais. Professor Revati, distinguished members of the teaching faculty, my colleagues from the Warangal Bar Association, prominent citizens of this great place, our Karakias, of course, the future of the nation, my dear students and research scholars of the university, distinguished members from the media, if any, ladies and gentlemen. I must express my gratitude to Prof B.Janardhan Memorial Foundation for giving me this opportunity to be present here and interact with you. I consider it to be a great privilege to be here and deliver this memorial lecture. Professor Rao was a person of exceptional integrity, and he brought to his scholarship and his activism a deep, empathetic understanding of the human dignity inherent in all, irrespective of their status in society. In his academic and social work, relating to the issues confronted by tribal communities, and in his untiring efforts to promote the cause of statehood for Telangana, he was guided by the core principles of social justice. To be able to pay our respects to such a soul is to be afforded a fresh chance to rededicate ourselves to the cause of social justice and thereby reconnect with our own humanity. I must also place on record our debt of gratitude to the family of Professor B.Janardhan Rao for sharing him with us in his lifetime and sharing his memories with us through these memorial lectures. Mrs. Rao, your family continues to enrich us all as human beings. Thank you. I speak about the cause of Telangana. What else? If it is Professor B.Janardhan Rao Memorial Lecture, what else? To speak about anything else at this memorial lecture, while the dignity of Telangana is being denied, would mean that we would have to be untrue to the memory of Professor B.Janardhan. There are many aspects to Telangana, its history, its culture, its people, and of course, the injustices suffered by Telangana's, especially those at the bottom of the social totem pole. We have spoken about such injustices and have waged a ceaseless struggle for nearly 6 decades now for statehood of Telangana within the constitutional structure of the sovereign democratic Republic of India. Yet over such a long period, the same issue finds sustained emotional response amongst the people of this region. Is indicative of the extent of discrimination and injustices suffered by them, particularly those belonging to socially disadvantaged segments. Let there be no doubt that the question of Telangana is one of consistent and extensive moral, political, and constitutional neglect by successive governments at the levels of Union of India and the state of Andhra Pradesh. I have chosen to speak about the issues of statehood of Telangana from a constitutional perspective. This is important both for those who live in Telangana as well as other citizens, with even a modicum of respect for constitutional values, because certain features and aspects of the Constitution are being deliberately ignored and flagrantly violated by the powers that be. Specifically, this lecture will touch upon the constitutional goals of justice, social, economic and political, the promise of promotion of a fraternity that assures the human dignity of individuals, the extent of powers vested in the Union of India in Article 3 of the Constitution, and imperatives of Article 38 of ensuring social justice in all walks of life and national institutions, and eliminate inequalities in status, facilities, and opportunities, not only of individuals, but also amongst the groups of them living in different areas. The denial of statehood for Telangana over the past 6 decades, and the delaying the formation after the Government of India made an official announcement on December 9, 2009, constitutes a fraud on the face of the Constitution. The analysis that I will present here is not intended as an argument in a court of law. Whether a constitutional court would take cognizance of such issues depends on many factors, including the assessment of jurists as to whether deeply political aspects are amenable to judicial resolution at a particular point in time. Nevertheless, descriptions and analysis of constitutional neglect in the context of governance and political discourse is vital for the health of the constitutional project. Alternatively stated, the argument that the constitutional values have been negated ought not to be premised only on the fact that constitutional courts have held so. Constitutionalism is a living spirit and a guide to social and political actions that maintain social harmony and promote human dignity of all cannot be seen as being merely dependent upon what a few judges say in view of billions of instances that the Constitution is implicated in daily life. Ours is a Constitution that unequivocally places affirmative obligations on the nation state, of which we the people are also a part to achieve a social transformation. Consequently, it is imperative that constitutional values be articulated in governance and political discourse to eliminate the conditions that truncate the delivery of protections assured and promises made in the Constitution to individuals and groups of people. It would also be reasonably surmised that such a practice would strengthen the social and political will to sustain the constitutional project. The goals of Constitution have been most eloquently articulated in the preamble. The purpose of constituting ourselves as a nation state was to assure for every citizen justice, social, economic, political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity. All the citizens' fraternity, assuring the dignity of the individuals and the unity and integrity of the nation. The preamble exhortations found an expression inter alia as an important imperative in Article 38 of the Constitution. It is important to point that aforesaid principles, though not enforceable by the courts, as stated in Article 37, are nevertheless fundamental in governance of the country, and the state shall apply those principles in making laws. Consequently, we must understand that the task of informing all national institutions with social justice and elimination of inequalities in status, facilities and opportunities of people residing in different regions to be fundamental to governance and indeed a duty of the state. The expression the state refers to both the central government as well as the government at the level of the subnational politico-administrative units such as individual states. The great souls who led us to the freedom and the framers of our Constitution had a vast understanding of human history, including the struggles of mankind to ensure the dignity of the individual and groups of them. The principal lesson learned by mankind by the time India became an independent nation state was that without justice prevailing in the affairs of people, peace and fraternity would not be possible, and that the only desirable political social collective was one which was informed by justice. A primordial task of a nation state is the promotion of fraternity, in which justice, equality and liberty would prevail, and thereby assuring the individual and groups of them their inherent human dignity. Such a task can be sustained if and only if every individual and groups of them feel the dedicated gaze of concern of the nation state as to the extent that conditions of justice, liberty and equality prevail as a consequence of constitutional governance. Where injustices and inequalities are allowed to fester and the expression of dissatisfaction with prevailing conditions is met with the repression as is happening in this part of the state, one would have to conclude that the soul of the nation state has been lost. Our freedom movement was one of intense struggle over a very long period against a colonial power that was indifferent to principles of justice, liberty and equality, and their application in the affairs of those they ruled. Our Constitution, by placing the goals of justice, equality and liberty, and the promise of fraternity that protects human dignity of individuals and groups as the very essence of governance, articulates the premise that soul of the nation would remain lost so long as such goals are not being consistently sought to be achieved and the pledge redeemed. The framework of the Constitution realized that unless freedom was used for and self-governance is attuned towards achievement of those goals, the lasting peace of a just fraternal order would not be feasible within the boundaries of the nation state that they were helping the people of India to constitute. To struggle for creation of an environment in which such a pursuit is unrelenting is a struggle to reclaim our national soul and the human dignity of all individuals, Indians. It is within an existing politico-administrative unit and a subnational level, such as a state, injustices and discriminations are perpetuated against vast swaths of people of an area of a region, then to not struggle for the creation of a new state that would enable those people to benefit from a proper constitutional governance is to abandon the soul of the Constitution. To not wage a peaceful but sustained struggle for the new state, especially when those who have suffered and continue to suffer previously belong to the most disadvantaged segments of our population, is to abandon our own claim to humanity and human dignity. In such a situation, the nation will be lost irretrievably. We attained our independence as one nation and constituted ourselves as a nation state. Local politico-administrative units such as states within the geographic region of that nation state cannot be deemed as permanent and inviolable entities. When we became a nation state, given the national purpose outlined above and our historical experiences, we placed the primordial, though not the sole responsibility of ensuring equitable social, political, and economic development of all the citizens and groups of them living in different regions, and of ensuring the sustenance of the hope that constitutional values evoke on the Union of India. One such primordial responsibility of Union of India is to redraw the boundaries of the state, and where necessary create new ones if people of any region are consistently being denied the benefit of anxious constitutional governance that seeks to achieve conditions of justice, equality, liberty, and a fraternal order in which human dignity of the individual and the group is protected. The Union of India is permanent within territorial limits, and those had to be indestructible. Inasmuch as the nation state of India was constituted to the people of India as a nation by our constitution, the indestructibility of the nation state is premised on the continuing faith of the people in the constitution itself. Within such an indestructible nation state, by virtue of Article 2 to 4 of the Constitution, the states and other similar political administrative units are not assured of any territorial unity. Pausing here for a minute. Of course, it's not there, it's in the part of the lecture. Many of my friends are present here in the bar, and even the distinguished vice chancellor. రాజ్యాంగంలో ఒక రాజ్యాంగబద్ధమైనటువంటి పదవులు నిర్వర్తించినప్పుడు ప్రమాణపత్రం I will uphold the territorial integrity and sovereignty of India. భారతదేశం సార్వభౌమాధికారాన్ని, భారతదేశం యొక్క జిల్లాలను కాపాడుతారు, పరిరక్షిస్తారు. ఆంధ్రప్రదేశ్ జిల్లాలను కాదు. ఆంధ్రప్రదేశ్ ముఖ్యమంత్రి ప్రమాణం చేసిన, ఆంధ్రప్రదేశ్లో ఉన్నటువంటి మంత్రులు ప్రమాణం చేసిన, ఆంధ్రప్రదేశ్లో ఉన్నటువంటి న్యాయమూర్తులు ప్రమాణం చేసిన, ఆంధ్రప్రదేశ్ సార్వభౌమాధికారాన్ని, ఆంధ్రప్రదేశ్ ఎల్లరను కాపాడతానని కాదు, ఎక్కడ లేదు రాజ్యాంగం. ఆయన అపోల్డ్ టెరిటోరియల్ ఇంటిగ్రిటీ అండ్ సావరెనిటీ. ఎందుకంటే రాష్ట్రానికి ఉండేటువంటి సరిహద్దులు ఎప్పుడైనా ఏ సమయమైనా పాల్గొంటున్నారు. 1, 2, 2, 3, 3, 4, ఎప్పుడైనా చెయ్యాలి. అది రాజ్యాంగం చెప్పేది. The Constitution itself recognizes the need for states in order to ensure better delivery of constitutional governance on account of legislative and executive competence within a limited set of fields that may have greater resonance and specificity at the local level. The permanence and inviolability of permanently marked boundaries of the state within the Union of India is neither assured nor would it appear as desirable if the very goal of delivery of benefits of constitutional governance do not reach individual or groups of them living in particular areas.